All right, so let's take a look at labor and employment law. And the first thing that we're going to talk about is discrimination, because employment law is really about, in many ways, prohibiting discrimination in the workplace. Federal discrimination laws are regulations that protect individuals from unfair treatment in the workplace based on certain characteristics: race, gender, age, disability, all examples of what we would call protected classes. These laws are enforced by agencies like the Equal Opportunity Employment Commission, or the EEOC. That is a federal agency, and a state agency as well. And they are designed to ensure fairness and equality in employment practices. Probably the most consequential piece of employment law is Title VII of the Civil Rights Act of 1964, which prohibits discrimination based on race, color, religion, sex, or national origin in hiring, firing, promotions, and other employment practices. It covers employers with 15 or more employees. So the employer can't say something like, or can't do something like fail to promote females in favor of males because they have these stereotypes about females needing to be at home and they're not going to be at work as often because they're the primary caregivers of children. Can't do that in the workplace. There are two types of discrimination that the 1964 Act protects against. The first is disparate treatment, which means that you are being treated differently specifically because you are in a protected class: race, religion, age, national origin. I'm forgetting one. I just said them 2 times though, so you know what they are. So that's disparate treatment. You can't fail to hire, fire, or promote somebody based on their position as a protected class. And then there's also something called disparate impact. And disparate impact is almost unintentional discrimination, but it happens because of it is current discrimination that happens because of past discrimination. So the example that I would give you for disparate impact is, for many years in the airline industry, pilots were always white males. And this was true going from the 60s up until about the mid-90s. And the reason for that was that most major US airlines hired former military pilots. That was where they got the bulk of their pilots. And former military pilots were increasingly, or were primarily, like over 99% at one point in the 50s, 60s, 70s, 80s, and 90s, white males. And so because of that, the airline pilot classes were primarily white males. And so in order to protect against that, airlines invoked what's called affirmative action, or they made a concerted effort to hire female and minority pilots to help diversify their pilot ranks. And so that was an example of disparate impact that now you see when you see pilots walking in through any airport. They could be white males, they could be black males, they could be black females. I have had all-female crews before, and that, even 20 years ago or 15 years ago, was something that you would rarely see. Disparate treatment, disparate impact. So there are some exceptions to Title VII where you can, for lack of a better term, or defenses, I should say, for lack of a better term, discriminate. The first is merit. If you show somebody earned the position because of their specific qualities, well, then that's a valid defense. Companies that have seniority systems in place, Maricosta College has a seniority system in place. Airlines frequently have seniority systems. A lot of public agencies, police organizations, fire organizations, a lot of that stuff is based on seniority. And so they look at somebody's seniority number when thinking about hiring, firing, promoting, things like that. And the last is what we call a bona fide occupational qualification, or a BFOQ. And a BFOQ basically says that in order for somebody to work in this job, we need them to meet a certain criteria. So, for example, somebody in a lingerie store, it is perfectly fine for a lingerie store to say, we are not going to hire males to work as changing room attendants. We might hire them to work the cash register, but our customers might be understandably uncomfortable with a man in the dressing room while they're trying to find new undergarments. So something like that, where there is a demonstrable need for a specific person for a specific job. Some additional federal discrimination acts: the Age Discrimination in Employment Act, or ADEA, of 1967, basically prohibits discrimination against individuals aged 40 or over. If you are 40, you are considered to be an older employee, and so there are special protections that come to place for folks that are older. The Americans with Disabilities Act of 1990 prohibits discrimination against qualified individuals with disabilities in employment and requires employers to provide reasonable accommodations. So an employer has to make reasonable adjustments to the workplace, such as providing an accessible workstation or things like that, to accommodate an employee with a disability. Equal Pay Act of 1963 requires employers to pay men and women equally for equal work in the same establishment. And this covers any employer with any number of employees. So a company can't pay a female less than a male employee if they are performing the same job under similar working conditions. Pregnancy Discrimination Act prohibits discrimination based on pregnancy, childbirth, or related medical conditions. Employers have to treat pregnancy the same as any other medical condition in terms of benefit and leave. This covers employers with 15 or more employees. And so an example, an employer can't fire or refuse to hire a woman because she is pregnant or may become pregnant. The only exception to this is for small businesses. If you can prove economic hardship, then you can replace a worker who is out on maternity leave. So you can't be fired unless the employer can prove economic hardship. Genetic Information Non-Discrimination Act of 2008 prohibits discrimination based on genetic information, including individuals' genetic tests of family medical history. So basically, your company can't use any genetic information to make employment decisions, such as refusing to promote somebody because of a family history of a medical condition. Folks with medical conditions tend to cost more in terms of insurance to the company if it's employer-paid benefits. And so this piece of legislation protects folks from that type of discrimination. Rehabilitation Act of 1973 prohibits discrimination against individuals with disabilities in federal employment and federal contractors. So this is specifically for federal agencies and basically says that they can't refuse to hire somebody with a disability if they're otherwise qualified for the job. So that was your basic federal discrimination overview. There are two types of employment in the United States. We have employment at will, and we have folks that work under labor agreements. And so if you have a contract, then you are working under some kind of employment agreement or labor agreement. If you are not, then you're what's called an employee at will. And basically what happens with employees at will is the employer can terminate you at any time for any reason or for no reason at all, as long as it's not what we would call a wrong reason. And I'll talk about the wrong reasons in just a moment. But something to know with employment at will is it works both ways. So your employer can fire you at any time, and you can fire your employer at any time. At any time, if you're an employee at will, you can say, you know what, this place isn't for me, I'm out of here, and leave in the middle of your shift if you want. I don't recommend it because it doesn't work out really well for your references for the next job that you try to get. But employees do have that right to leave at any time. What are the wrong reasons? First of all, refusing to violate the law. If your employer asks you to do something that is illegal and you refuse, you cannot be fired for that. Exercising a legal right, like exercising your right to vote, your employer has a legal obligation to give you time off to vote. Performing a legal duty, like jury service. If you get a jury summons, your employer cannot fire you for performing that legal duty. And then public policy. Employers cannot fire employees for violating public policy. And that would be like filing for workers' compensation, reporting unethical activities. Those are all activities that as a society we deem as important. And so if you are doing something, if you do something that is akin or that is in concert with good public policy and your employer fires you for it, that is also a wrong reason. So some additional employment related acts. The Federal Plant Closing Act basically says that if a large employer is going to have to do a massive layoff, they have to provide a warning period. Generally, it is a 60-day warning that you receive that says that you are going to be laid off, and this is the approximate date. Employee Polygraph Protection Act basically gives you workplace protections against your employer requiring you to take a polygraph. There are some exceptions to that. If you get hired into law enforcement, for example, in some military jobs, they are legally allowed, or they can give you a polygraph test. Occupational Safety and Health Act, or OSHA, legislation that keeps the workplace safe. And I think we've talked about OSHA, that's in statutory or administrative law, somewhere. We've talked about OSHA. Fair Labor Standards Act basically puts workplace protections in place. So things like there's a minimum working age, we can't send 12-year-olds to work, and establishes the minimum wage, and also workers' compensation laws that basically say that if you get hurt at work, your employer has to cover the cost of your rehabilitation from that workplace-related injury. Moving on to labor law. And so labor law is really about the creation of unions in the workplace and the work done by organized labor. And so back in the Industrial Revolution, when factories were really starting to ramp up and we were really starting to come into an age of mass production, working conditions were really harsh. People worked long hours for very little pay, and there were minimum worker protections. So things like child labor was common, unsafe working conditions, and people worked up to 16-hour days. And so early labor unions began to form to protest these conditions. But they faced legal challenges because unions were often considered to be illegal. Some early legislation, Sherman Antitrust Act, I'm going to talk about this when we get to securities as well, because it was intended to prevent monopolies, but it was often used to suppress labor unions by deeming strikes as unlawful restraints of trade. And so this was an early challenge for the labor union, as strikes were restricted under antitrust laws. The Clayton Antitrust Act modified the Sherman Act by exempting unions from being considered illegal monopolies. So the Clayton Act gave workers the right to organize and strike. So it was a big victory for labor rights, allowing unions to grow in strength. And then some early legislation additionally was the Fair Labor Standards Act, or the FLSA, which it established the minimum wage, granted overtime pay, and put restrictions on child labor. So this was a really, really big win for labor. It also set the 40-hour work week and gave us time and a half pay for overtime. And then in the New Deal during the Roosevelt administration, we have the National Labor Relations Act, also known as the Wagner Act. The NLRA established the right of workers to form unions, bargain collectively, and engage in strikes without employer interference. So it really strengthened labor rights, allowing unions to grow, and improved workers' bargaining power. It also established the NLRB, or the National Labor Relations Board, an independent federal agency to oversee labor disputes and union elections. Social Security Act introduced our national retirement system. It also provided unemployment insurance, again, retirement, old age pensions, and benefits for the disabled. Fair Employment Practices Committee in 1941 was created to ban discriminatory employment practices based on race, color, and national origin. in federal agencies and defense industries during World War II. And so this really marked the beginning of federal intervention into discriminatory labor practices, and it was a precursor to that 1964 act. So the Taft-Hartley Act was passed to help balance the power between labor and management, because there was a perspective that unions were getting a little too much power, because a union could come in and say, you cannot work in this company until you join, or if you get the job, you must join the union. And so that's what's referred to as a closed shop. Taft-Hartley banned that. So now, because of Taft-Hartley, when you join a company that has unionized labor, you can choose to join the union or not. And so it limited the power of unions, giving the employers a little bit more leverage in labor disputes. We already talked about the Civil Rights Act of 1964. OSHA established federal regulations to ensure safe and healthy working conditions by setting and enforcing workplace standards. So basically, it gave you protections, or gave us as workers protections against workplace hazards, and it gave us the right to report unsafe working conditions without fear of retaliation from our employers. Some modern labor reform, the FMLA, or the Family and Medical Leave Act of 1993, provides employees with unpaid, up to 12 weeks, unpaid job-protected leave for family and medical reasons. So it gives you the ability to take for yourself or to take care of a family member without fear of losing your job. Remember that FMLA is unpaid, however. ADA, the Americans with Disabilities Act, prohibits discrimination based on disability and requires employers to provide reasonable accommodations to disabled employees. This expanded workers' rights by ensuring access and accommodations for employees with disabilities. The Affordable Care Act expanded health care access to workers by requiring employers to provide health insurance to full-time employees or face penalties. And so this strengthened worker benefits by ensuring health care coverage was universal and gave protections for pre-existing conditions. So I talked a little bit about the National Labor Relations Board. It is an independent federal agency that consists of 5 board members appointed by the president and confirmed by the Senate. They serve for 5-year staggered terms. So really it's structured by design so that the president has very little influence on the NLRB, because the terms are staggered. A president might be able to appoint maybe 1, maybe 2 people, but that's it. The NLRB has 2 functions. It investigates allegations of unfair labor practices and provides remedies in appropriate cases. And it decides in contested cases which union should serve as the exclusive bargaining agent for a particular group of employees. So let's talk about the union. The union is the collective bargaining agent for the labor group of employees. What that means is that when you are in a union, you don't get to go and negotiate a pay raise for yourself. An employee at will has the ability to do that. Employees in a collective bargaining group are represented by the union, and the union is their exclusive agent. In order to form a union, you need 50% of the employee group. It's 50% plus 1, actually, that has to sign a petition that says that they all want to be part of a union. Unions are required to bargain in good faith, and they retain the right to strike if they cannot come to an agreement with the employer about pay, working conditions, whatever it may be. There was a recent Supreme Court ruling known as the Janus decision that basically said that, now what typically happened prior to Janus was that if you have a right to not be in the union, but you still had to pay the fees, even if you didn't want to be in the union, because the union still represents you. The Janus decision basically said that forcing non-members to pay union fees violates their free speech rights. So paying union dues needed to be voluntary. And it gave government employees the right to choose whether or not they wanted to join a union. Typically with government jobs, you have to be in the union. Before that ruling, public employees were required to join their union and pay union fees and dues. And so this decision was the 3rd and final act in a series of cases aimed at eliminating what are called fair share fees. If you choose to not be in the union, you still had to pay what's called your fair share, which was your equivalent of dues and fees for having the union represent you, even though you didn't want to be part of it. So Janus basically said that if you choose not to be in the union, you also don't have to pay the fees, but the union still has to represent you in terms of you get you get the benefits of what has been collectively bargained for. So that's it, an overview of employment and labor laws. Quite a bit here. This was a brief overview considering the vastness of employment and labor law. But really the important things are to understand the differences between what happens in a union and what happens with at-will employment, because they are vastly different, as well as some of those federal protections that you have vis-a-vis our federal discrimination laws.